Good evening, everyone. A very warm welcome to today's special webinar hosted by LiveLaw Academy. I'm Kritika Goyal, and it's truly a pleasure to see so many bright and curious legal minds joining us this evening. Today's session focuses on a concept that forms the very bedrock of our criminal justice process, taking cognizance of an offense by a magistrate. Before we begin, it's both my honor and a privilege to introduce the guiding force behind this session, Justice V. Ramkumar, sir, our patron and chief mentor at LiveLaw Academy. Justice Ramkumar, sir, is a distinguished former judge of the High Court of Kerala. Sir began his legal journey with an LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, Sir was directly recruited as a district and sessions judge. Sir later served as law secretary to the government of Kerala and was elevated as a permanent judge of the Kerala High Court in 2004, a position which Sir held with great distinction until his retirement in 2012. Over the years, Justice Ramkumar, sir, has also delivered and served as a chairman of the advisory board under the Kerala Anti-Social Activities Prevention Act, as well as the Ombudsman for the Kerala Cricket Association. He is a much sought-after speaker, regularly invited by judicial academies, law universities, and bar councils to address judicial officers, prosecutors, and students alike. His contribution to legal literature includes acclaimed books like Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magisterial Trials, Law and Procedure. Sir's unique way in Q&A style, legal articles and live law have helped decode tough concepts for students and practitioners alike. And now, without further ado, let's all welcome Justice Ramkumar, sir.
Thank you, Kritika. Good evening, friends. The topic for today is taking cognizance of an offense by a magistrate. It's a very important topic because every lawyer practicing on the criminal side and every judge or magistrate dealing with criminal law should have a sound knowledge of this topic, because the problem is, unlike a civil court, criminal court does not have any inherent power. If it is a civil court, any procedural mistake, error committed by the civil court can be corrected by the civil court itself by recourse to section 151 CPC. But you don't find a provision corresponding to section 151 CPC in the CRPC or in the BNSS. Therefore, in fact, that power of inherent power has been conferred only on the high courts, not even on the sessions courts. Therefore, if a wrong step made by a magistrate or a consequent on the wrong submission made by the counsel or by the public prosecutor, the magistrate cannot rectify that mistake by tracing backwards. He or the party concerned, the prosecutor or the defense lawyer, the accused, will have to approach the high court for rectification. That is the problem. So the criminal courts are not armed with inherent powers. That difficulty, that disability should be always borne in mind by the magistrates, judges, and lawyers. With that, we go to the subject. Kritika, please read question number 1.
Yes, sir. I'm just sharing my screen.
Okay.
So, question number 1.
Yes.
Which are the sources available to a magistrate for taking cognizance of an offense?
The 4 sources I have given as by way of an answer to you. See that chart. There are 4 sources available to a magistrate for taking cognizance of an offense under section 210(1) of BNSS, that is Bharatiya Nagarik Suraksha Sanhita 2023. We will mention the abbreviation as BNSS. The corresponding section of the Code of Criminal Procedure 1973 is Section 190, Clause 1. Those four sources are: 1. Upon receiving a complaint of facts, which we loosely call a private complaint. Upon receiving a private complaint of facts constituting the offence. Complaint has been defined under Section 2(1)(h) of BNSS, corresponding to Section 2D CRPC. You may refer to that complaint. Therefore, upon receiving a private complaint, magistrate can take cognizance of the offence. Second source, upon receiving a police report of such facts. Police report has been defined under Section 2(1)(f) of BNSS, corresponding to Section 2R CRPC, to mean a report filed before the magistrate under Section 193(2) of BNSS, corresponding to Section 173(2) CRPC, by a police officer after conclusion of investigation. Third is C. Third source is C. C contains two separate sources. First source is information received from any person other than a police officer. So, information received from a police officer is a police report or a complaint by a police officer. Now, information received from any person other than a police officer. Can you conceive of a situation where the magistrate gets information from a person other than a police officer? Where a magistrate takes cognizance of the offence on the materials produced by the police, but disagreeing with the conclusion in the closure report. See, the police have got the power to file a police report after investigation. After investigation, if the offence is made out, police will file a police report charge sheeting the accused. Now, if the offence has not been made out, the police will not file a charge sheet. Police will file a refer report before the magistrate, saying that offence is not made out. Now, these are the information given by the police. Now, supposing what is filed by the police is a closure report, refer report, stating that no offence has been made out in my investigation. Magistrate peruses the records, including 161, the statements under Section 161 CRPC, that is 180 BNSS of witnesses. Then magistrate finds out that in one statement by a witness, he has clearly mentioned about the offence committed and about the offender also. This was either mistakenly or knowingly suppressed by the police officer. That is why he filed a closure report. Now, magistrate finds out that from the records produced by the investigating officer himself along with the police report. So, he is now relying on the information given from a person other than a police officer. This is one such source, one such example of information received from any person other than a police officer. Yet another situation is, supposing an accused person has been arrested by the police officer and produced before the magistrate. Magistrate asks him, do you have any grievance against the police? He says, yes, I was manhandled, ill-treated by this police officer, by the station house officer and his assistants. This is an information received by the magistrate from a person other than a police officer. It also falls under this clause. Yet another situation is extrajudicial information by way of letters, newspapers reports, news channel reports, internet information, etc. to vindicate justice received by a magistrate. These are also information received from any person other than a police officer. On these information, the magistrate can take cognizance under clause C of section 210. Now, the second source under clause C, the own knowledge of the magistrate that such offence has been committed. This is when the offence has been committed in the very presence of the magistrate. Take for instance, the magistrate is having his evening stroll after reaching home from the court. He is having his evening stroll. While going along the road, a cognizable offence is committed in his very presence. That is a situation where this clause is attracted. The own knowledge of the magistrate that such offence has been committed. In the case of these two subclauses under clause C, that is information received from any person other than a police officer, then second clause, the own knowledge of the magistrate, particularly own knowledge of the magistrate, because when a magistrate, when an offence is committed in the very presence of the magistrate, he becomes an informant. He is not merely a magistrate, he becomes an informant. Therefore, under section 211 BNSS, corresponding to section 191 CRPC, there is a requirement that the magistrate should tell the accused, see, I have found you committing this cognizable offence. So, I am in the position of a complainant, therefore, or informant. Therefore, do you want me to try the case or do you want some other magistrate to try the offence? This option is to be given. What is that principle? What is the principle behind that option? Nemo judex causa sua. No person shall be a judge in his own cause. So, magistrate who has stepped into the shoes of the complainant or the first informant is telling the accused, please tell me whether I should myself try the offence because I am the complainant. I saw the offence being committed. Therefore, there is every chance of maybe I having a prejudiced view. You just tell me whether I should commit it. And if he exercises his option, says it may be sent to some other magistrate, the magistrate will have to send it to yet another magistrate. So these are the four sources for taking cognizance. Which are the four sources? A, upon receiving a complaint of fact, private complaint. B, upon receiving a police report, that is charge sheet, etc., or refer report, etc. C, upon information received from a person other than a police officer and the own knowledge of the magistrate that such offence has been committed. These are the four sources of taking cognizance of an offence under section 210(1) BNSS corresponding to section 190 clause 1 of CRPC. Now there are some decisions which say that there are three sources only. There are only three sources. No. Actually there are four sources. We have seen that. A, B, C. C contains two separate sources. Therefore, in fact, a constitutional bench of the Supreme Court in A.R. Antule versus R.S. Nayak, AIR 1984, Supreme Court 718, corresponding to 1984, Volume 2 SCC 500, 5 judges speaking through Justice D.A. Desai, has noted that the sources for taking cognizance are four known methods for taking cognizance. Now, the usual sources for taking cognizance which normally come up for adjudication before court are police report and private complaint. We will now deal with private complaint. Please read question number 2.
So, question number 2. On receiving a complaint, private complaint, filed under section 2(1)(h) of BNSS, that is section 2D of CRPC, the magistrate goes through the complaint and the documents produced along with it. Noticing that it is time for him to raise for the day, the magistrate directs the complainant and his witnesses to come on the next day for recording their sworn statements under section 223 BNSS, that is section 200 CRPC. The magistrate also makes an endorsement to that effect in the proceedings sheet. Has the magistrate who has not recorded the sworn statements taken cognizance of the offence?
This is a question. Around 4 p.m., magistrate receives a private complaint before him. The complainant and his witnesses are before him. Magistrate reads the complaint thoroughly and the document produced along with the complaint. Then he looks up at the clock. Oh, it is 5 o'clock, time for me to rise. Then he asks the complainant and his witnesses to come on the next day for recording their sworn statement. But he has not recorded their sworn statement. He also makes a record in the proceeding sheet. Complainant present, witnesses present. I have directed them to come tomorrow for recording the sworn statement. Sworn statement is yet to be recorded. Question is whether the magistrate has taken cognizance of the offence alleged in the complaint. Can anyone answer this? Has he or has he not? He has not recorded his own statement. That will be recorded only tomorrow, next day. The answer is yes. The magistrate has taken cognizance of the offence. You will be trying to answer that no, he has not taken cognizance because he has not recorded the student statement. No. If after perusing the rule is this, if after perusing the complaint and the documents produced along with the complaint, the magistrate applies his mind for the purpose of proceeding under chapter 15 CRPC, that is chapter 16 BNSS, starting with section 200 CRPC, that is section 223 BNSS. If the magistrate decides to proceed under chapter 16 BNSS, the magistrate can be said to have taken cognizance of the offence. It is not necessary that he should actually record the sworn statement of the complainant or the witnesses. It is enough if yes. Now, there can be a situation where magistrate, after reading the complaint, simply adjourns it to the next day without making any decision, without expressing his mind. There he has not taken cognizance. But here he has decided to proceed under chapter 16 BNSS, that is starting with section 223 BNSS. In that case, the magistrate can be said to have taken cognizance of the offence. You should never forget this. No magistrate, no judge, or no lawyer practicing on the criminal side should forget this great principle. In fact, there are more than a dozen rulings by the Supreme Court, but there are some other decisions which cause some confusion. You may stick to these rulings, which I am going to give you now. R.R. Chari versus State of UP, AIR 1951 Supreme Court 207. AIR 1951 Supreme Court 207. 3 judges. The judges are M.H. Kania, Chief Justice of India, Patanjali Shastri, and S.R. Das, all great judges. In paragraph 10, Chief Justice Kania has bodily extracted and approved an observation made by Justice Das Gupta of the Calcutta High Court in Superintendent and Remembrancer of Legal Affairs West Bengal versus Alani Kumar, AIR 1950 Calcutta 437, where Justice Das Gupta in the course of his observation observed he must not only have applied his mind to the contents of the petition, but he must have done so for the purpose of proceeding in a particular way, as indicated in the subsequent provisions of this chapter, that is chapter 15, starting with section 200 CRP, proceeding under section 200 and thereafter, sending it for inquiry and report under section 202. When this is the great observation made by Justice Das Gupta of Calcutta High Court way back in 1950. This was bodily lifted and incorporated in the judgment in R.R. Chari by the 3-judge bench decision authored by Chief Justice Kania. Now, this Justice K.C. Das Gupta of Calcutta High Court was later elevated to the Supreme Court. The above observation by Justice Das Gupta in AIR 1950 Calcutta was again extracted by Justice Arijit Pasayat in para 13 of Muhammad Yusuf versus Jahan, Srimati Afjahan, AIR 2006 Supreme Court 705, AIR 2006 Supreme Court 705. Again in para 19 of Dilawar Singh versus State of Delhi, AIR 2007 Supreme Court 3234, again by Justice Arijit Pasayat, AIR 2007 Supreme Court 3234. This is the first decision. This is the earliest decision on taking cognizance on a private complaint. Second decision is Narayan Das Bhagavan Das versus State of West Bengal. AIR 1959 Supreme Court 1118 1118. AIR 1959 Supreme Court 1118. Towards the end of paragraph 8, you will find this observation. It is only when a magistrate applies his mind for the purpose of proceeding under section 200 and the subsequent sections of chapter 15 of the Code of Criminal Procedure or under section 204 of chapter 17 of the code that it can be positively stated that he had applied his mind and therefore had taken cognizance. See, so it is not enough, it is not necessary that he should actually record the own statement of the complainant and his witnesses. It is enough if that after reading the complaint, he applies his mind for the purpose of proceeding under section 200 CRPC corresponding to section 223 BNSS and the subsequent sections of that chapter. Third decision is Gopal Das Sindhi versus State of Assam. AIR 1961 Supreme Court 986. 3 judges. Judges are S.J. Imam, he is the author of the judgment, K. Subbarao and Raghubar Dayal. These observations regarding taking cognizance on a private complaint are to be found in paragraph 7. Then fourth decision is Jamuna Singh versus Badai Shah. Jamuna Singh versus Badai Shah. AIR 1964 Supreme Court 64. 1964 Supreme Court 1541. 3 judges. B.P. Sinha, Chief Justice, M. Hidayatullah and K.C. Das Gupta, formerly of the Calcutta High Court. K.C. Das Gupta. Author is K.C. Das Gupta. He is the very same judge whose judgment, whose observation was bodily lifted and extracted in the judgment in R.R. Chari and Jamuna Singh. Then fifth citation is Nirmaljit Singh Hoon. Nirmaljit Singh Hoon versus State of West Bengal. AIR 1972 Supreme Court 2639 corresponding to 1973 3 SCC 753. Again 3 judges. Justice J.M. Shelat, Justice D. Dua and H.R. Khanna. Justice J.M. Shelat is the author of the judgment. You may refer to paragraph 35. Paragraph 35. Then sixth citation is Devarapalli Lakshmi Narayana Reddy versus Narayana Reddy. AIR 1976 Supreme Court 1672. AIR 1976 Supreme Court 1672. 3 judges. Justice R.S. Sarkaria, one of the greatest judges on the criminal side. P.N. Shingal and Jaswant Singh. They are authored by Justice R.S. Sarkaria. Then comes seventh citation. Mohammad Yusuf versus Afaq Jahan. Srimati Afaq Jahan. AIR 2006 Supreme Court 705 corresponding to 2006 1 SEC 627. Authored by Justice Arijit Pasai. Then eighth citation is State of Karnataka versus Pastor P. Raju. AIR 2006 Supreme Court 2825 corresponding to 2006 Volume 6 SEC 728. Judges are G.P. Mathur and Dalvir Bhandari, authored by Justice G.P. Mathur. R.R. Chari and Narayan Das followed here. Ninth citation is Dilawar Singh versus State of Delhi. AIR 2007 Supreme Court 3234. Arijit Pasai. Paras 15 to 21. 10th citation is S.K. Sinha, Chief Enforcement Officer versus Videocon International Limited. AIR 2008 Supreme Court 1213. The author of the judgment is C.K. Thakkar, Justice C.K. Thakkar. The other judge is P.P. Navlekar. 11th citation is Fakhruddin Ahmad. versus State of Uttaranchal, 2008, volume 17 SEC 157. 157. Judges are Justice C.K. Thakkar and D.K. Jain. Justice D.K. Jain being the author of the judgment. Then comes Mona Panwar versus High Court of Judicature of Allahabad, 2011, 3 SEC 496. Here, what happened was the author of the judgment is Justice J.M. Panchal. Here, the appellant before the Supreme Court was a lady magistrate. Instead of there was a complaint before her, complaint to the police under section 156(3). In fact, she had forwarded the complaint under section 1. In fact, the request of the complainant before her was to forward the complaint to the police under section 156(3), as was prayed for. But instead of forwarding the complaint to the police, she directed the complainant victim in a rape case to appear before her for taking cognizance of the offence. This order of the magistrate appellant was challenged before the High Court, and a learned single judge of the High Court not only set aside the said order, but made some disparaging remark against the lady magistrate. The Supreme Court not only approved the action taken by the magistrate, but also expunged the remarks made by the High Court against the lady magistrate, who was constrained to approach the Supreme Court for redressal of her grievances. Because even if the complainant in a private complaint requests that the matter may be forwarded to the police for investigation, magistrate is not bound to do that. Magistrate can either forward it to the police for investigation, in which case he is not taking cognizance of the offence, but he can also record the own statement of the complainant and take cognizance of the offence and proceed further. What the magistrate did in that case was to proceed further after taking cognizance, because she noticed that a complaint to the police had been was not accepted. The police had refused to record the first informant of the complainant. So there is no point in going to the police again. That is why the magistrate did that. In fact, the learned judge of the High Court was not correct in making aspersions against the magistrate. 13th citation is Dr. Subramania Swamy versus Dr. Manmohan Singh, 2012, volume 3, SEC 64. Justice G.S. Singhvi and Justice A.K. Ganguly, Justice Singhvi being the author. Then these earlier three judgments, R.R. Chari, Gopal Das Sindhi, and Jamuna Singh, and S.K. Sinha, 4 judgments, which I have already referred to, were approved by a constitution bench of 5 judges in Sarah Matthew versus Institute of Cardiovascular Diseases, AIR 2014 Supreme Court 448, 5 judges, corresponding to 2014 volume 2 SEC 62. The judges are P. Sadashivam, Chief Justice, B.S. Chauhan, Dr. B.S. Chauhan, Ranjana Prakash Desai, the author of the judgment, and Ranjan Gogoi and S.A. Bobde. The constitutional bench approved the 4 of the earlier decisions. So it is now the law of the land that it is only if the magistrate, after perusing the complaint and the documents, applies his mind for the purpose of proceeding under section 223 BNSS, that is section 200 CRPC, he can be legitimately stated to have taken cognizance of the offence. Actual recording of the statement of the complainant and the witnesses is not necessary. That is a subsequent stage, or rather a post-cognizance step. Then one important decision which you may bear in mind is mere application of mind does not amount to taking cognizance of it. In fact, one judicial officer asked me, sir, is it not correct that the magistrate applies his mind, he has taken cognizance of it? No. Mere application of the mind will not amount to taking cognizance of it. The application of the mind should be for the purpose of proceeding under section 200, that is 223 of BNSS. Then only the magistrate can be said to have taken cognizance of the offence. You may refer to Kishun Singh versus State of Bihar, 1993, volume 2 SEC, page 16. 1993, volume 2 SEC, page 16. And the judges are A.M. Ahmadi and N.P. Singh, Justice Ahmadi being the author. Then also Mona Panwar, I already referred to. Mona Panwar, that is year 2011, volume 3 SEC, 496, Justice J.M. Panchal. So these are the great decisions which have held that magistrate, when does a magistrate take cognizance of an offence on a private complaint? Now, there was a misconceived notion that it is only when the magistrate issues process under section 204 CRPC, that is 204 is section 227 of BNSS, that he can be said to have taken cognizance of it. In fact, it's a wrong view. When I was the judge of the Kerala High Court, puny judge of the Kerala High Court, I was invited in the National Judicial Academy for addressing the newly recruited session judges in certain North Indian states, including Punjab. When I went there, I found that two other judges were also similarly invited. One from Odisha and another from Patna. I was addressing the trainees on taking cognizance of the offence. While so, one judge, one of the judges who were sitting with me, told me, brother, you are not correct. Cognizance is taken only when the process is issued. When process is issued. I told the great judge that no, process is issued at the post-cognizance stage. Process, the magistrate is not taking cognizance when he issues process. When he decides to proceed under chapter 15, cognizance is already taken. Recording of sworn statement, issuing process are all post-cognizance steps taken by the magistrate. Anyway, he did not press that point anyway. Of course, he became a judge of the Supreme Court. I continued to be a judge of the High Court and retired. Now, for this, why I mentioned this was in Kref Finance Limited versus Sri Shanti Homes Private Limited, 2005, volume 7 SEC 467. Judges are BP Singh and SH Kapadia. And yet another decision, State of Karnataka versus Pastor P. Raju, 2006, volume 6 SEC 7 to 8. Justice G.P. Mathur, author, and Justice Dalveer Bhandari. They have emphasized the fact that the issuing process is at the subsequent stage. The magistrate is not taking cognizance of the offence by issuing process. Issuing process is at the post-cognizance stage. Therefore, never make any mistake that cognizance is taken when process is issued. No, process is issued at the post-cognizance stage. Please note that. That is why I mentioned this thing. Now, even the fact that the actual examination of the complainant and his witnesses is at the post-cognizance stage is indicated by section 211 BNSS itself, that is corresponding to section 191 CRPC. When a magistrate takes cognizance of an offence under clause C of subsection 1 of section 210, that is clause C of subsection 1 of section 190 CRPC, that is when the offence has been committed right in his presence, accused shall, before any evidence is taken, this is what the section says, the accused shall, before any evidence is taken, be informed that he is entitled to have the case inquired into and tried by another magistrate. So what does it show? It is after taking cognizance of the offence that the magistrate proceeds to take evidence. What is evidence? Evidence means the inquiry under section 200 and 202 CRPC. It was so clarified by another constitutional bench in Hardeep Singh versus State of Punjab. 5 judges. Hardeep Singh versus State of Punjab, 2014, volume 3, SEC 92. Therefore, a magistrate taking cognizance of an offence before taking evidence shall inform the accused that if he wants, the inquiry and trial can be before another magistrate. This section also clarifies or rather reinforces our stand that cognizance is taken even before recording of sworn statement. So therefore, by taking cognizance of the offence, the magistrate has only taken judicial notice of the offence. But he will have to further consider whether, on the facts of the case, process should be issued to the accused. The purpose of examining the complainant and his witnesses is to find out whether the complaint is false or vexatious. That is the purpose of examining the complainant and the witnesses. This was so observed towards the end of paragraph 9 of Mona Panwar, which I referred to earlier, 2011, volume 3, SEC 496. With that, we have completed question number 2. Am I clear now regarding the...
Yes, sir, absolutely.
Yes. Question number 3.
So question number 3. On receiving a complaint, the magistrate recorded the sworn statement of the complainant and the only 2 witnesses present. Since the magistrate entertained some doubts, he, however, posted the case for inquiry under section 225 of BNSS, that is 202 of CRPC. Has the magistrate taken cognizance of the offence?
What should be your answer? 2 witnesses were complainant and 2 witnesses were present. He recorded their statements, but he was still in a doubt. Therefore, he posted the case for inquiry under section 202 CRPC. That is, 202 is 225 BNSS. He posted the case for inquiry. Has the magistrate taken cognizance of it? He is yet to conduct the inquiry.
So I believe yes.
You are absolutely right. You have been applying your mind to whatever I said earlier. The moment the magistrate decided to examine the complainant and the witnesses, he decided to examine the complainant and the witnesses. He had already decided to proceed under section 223 BNSS, that is section 200 of CRPC. He had taken cognizance. Now, what is the doubt entertained by him? The doubt entertained is whether he had and could have entertained. The only doubt which he had and which he could have entertained is whether there was sufficient ground for proceeding. Whether there was sufficient ground for proceeding. It is only for clearing that doubt. He has taken cognizance of the offence, right? That is, he has taken judicial notice of the offence. But that is not enough. Offence is there in the complaint, alleged in the complaint. He has taken judicial notice of by proceeding to examine the complainant and the witnesses. But then, why should he examine the complainant and the witnesses? Mona Panwar, to find out whether the complaint is false or vexatious and whether there is sufficient ground for proceeding against the accused by issuing process. This is the purpose of inquiry under section 202 CRPC, that is section 225 of BNSS. So, cognizance is already taken. This question was put by me only to confuse you. So, you are very correctly, Kritika has very correctly answered the question. So, he had already taken cognizance of offence. He has taken judicial notice of the offence. Offence is very clearly alleged in the complaint. But he will have to further examine, he will have to further decide whether the complaint is false or vexatious as against the accused. And should he issue process to the accused? For that, he should have sufficient ground for proceeding. It is for that purpose that this inquiry under Section 202 CRPC, Section 225 BNSS is conducted, not for any other purpose. Now, the expression sufficient ground for proceeding is a common yardstick for conducting an inquiry under Section 225 BNSS, 202 CRPC, for dismissing the complaint under Section 203 of CRPC, that is 236 of BNSS, and for issuing process to the accused under Section 207 1 BNSS, that is Section 204 1 CRPC. If you examine these three sections, you will find the common yardstick of the existence or otherwise of sufficient ground for proceeding. Now, see, for example, Section 225 1 BNSS corresponding to Section 202 1 CRPC. I will read only the relevant portion. Any magistrate, on receipt of a complaint of an offence of which he is authorized to take cognizance, may, if he thinks fit, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit, for the purpose of deciding whether or not there is sufficient ground for proceeding. So 202 inquiry under CRPC corresponding to 225 1 BNSS is for the purpose of deciding whether there is sufficient ground for proceeding, not for taking cognizance. This inquiry has nothing to do with cognizance. Then the other section, Section 226 BNSS, that is Section 203 CRPC, for dismissing the complaint. Dismissal of complaint, 226. If after considering the statements on oath, if any, of the complainant and the witnesses, and the result of the inquiry or investigation, if any, under Section 225, the magistrate is of opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint. He shall dismiss the complaint. And in every such case, he shall briefly record his reasons for so doing. Why reasons? Because he is prematurely terminating the proceedings. Therefore, he has to give reasons. So, here again, the yardstick is existence or otherwise of sufficient ground for proceeding. Then the third section, first part of Section 1 of Section 227 BNSS, corresponding to Section 204 CRPC, reads as follows. If in the opinion of a magistrate taking cognizance of an offence, there is sufficient ground for proceeding, then only he can issue process to the accused. Thus, the purpose of inquiry under Section 225 BNSS, that is 202, Section 202 CRPC, is for finding out whether there is sufficient ground for proceeding. Likewise, if there is no sufficient ground for proceeding, the magistrate has no option except to dismiss the complaint under Section 226 BNSS, that is 203 CRPC. Similarly, the magistrate will issue process even after taking cognizance, even after conducting inquiry. The magistrate will issue process under Section 227 BNSS corresponding to Section 204 CRPC, process to the accused for his appearance before court only if there is sufficient ground for proceeding. So I wanted to confuse you by giving this problem. So once he has taken cognizance, the subsequent inquiry is not for taking cognizance, but to decide whether there is sufficient ground for proceeding only. Yes, I think you have understood the distinction. Have you?
Yes, sir.
Question number 4.
Question number 4. Whether on receipt of a private complaint alleging the commission of a cognizable offence, if the magistrate, instead of taking cognizance of the offence, orders an investigation under Section 175(3) BNSS that is section 156(3) CRPC, is the SHO bound to register an FIR and start investigation?
Magistrate receives a private complaint. Private complaint, he is not proceeding to take cognizance because the complainant had not approached the police at all. There is no allegation also that he approached the police and police refused to register an FIR, etc. Therefore, magistrate is directing the police, the local police, to conduct an investigation. He forwards the complaint to the police for investigation. Now, is the station house officer in charge of the police station, bound to register an FIR and start investigation? Because Lalita Kumari, the constitutional bench in Lalita Kumari's case held that even if the SHO is compulsorily bound to register an FIR which alleges the commission of a cognizable offence, he can refuse to enter on investigation if he feels that there is no sufficient ground, no case has been made out. If he feels that there is a provision under section 157 CRPC corresponding to the 176 of BNSS, which says that only when he has reason to suspect the commission of a cognizable offence, he need enter on his investigation. So, unless he has reason to suspect the commission of a cognizable offence, the SHO need not enter on investigation. That is the provision under section 157 corresponding to 176 BNSS. This was clarified by Lalita Kumari Constitutional Bench also, that even though he is bound to register the FIR, he need enter on investigation only if he has reason to suspect the commission of an offence. Now, here is a case where the magistrate forwards the private complaint to the SHO with a direction to conduct investigation. Question is whether he is bound to register the FIR and start investigation, or whether he can say that I don't have reason to suspect the commission of a cognizable offence. The purpose of sending the complaint to the police for investigation, sending it for investigation. Investigation presupposes the registration of an FIR. So, if the police are directed to conduct an investigation, they are bound to register an FIR and conduct investigation and submit a police report before the magistrate under section 193 clause 2 BNSS corresponding to section 173 clause 2 CRPC. You may refer to Suresh Chand Jain versus State of Madhya Pradesh, AIR 2001, Supreme Court 571. Justice K.T. Thomas is the author and R.P. Sethi. Then Madhubala versus Suresh Kumar, AIR 1997, Supreme Court 3104. M.K. Mukherjee and Sagir Ahmad. Justice M.K. Mukherjee is the author. Again, Samaj Parivartan Samudaya versus State of Karnataka, AIR 2012 SC 2326. And in Madhubala versus Suresh Kumar, AIR 1997, Supreme Court 3104, Justice M.K. Mukherjee being the author of the judgment, it was held that when once the complaint has been forwarded for investigation under section 156(3) CRPC corresponding to section 175(3) BNSS, the private complaint transforms itself into an FIR, and under section 173 BNSS, that is 154 CRPC, and thereafter it has to be registered and investigation started. No other go. Am I clear?
Yes, sir.
Question number 5.
Question number 5. It is illegal if the magistrate...
Is it illegal?
Is it illegal if the magistrate, after taking cognizance of the offence on a private complaint, orders investigation under section 175(3) BNSS, that is section 156(3) CRPC?
Yes, it is illegal. the power under section 175(3) BNSS corresponding to section 156(3) CRPC cannot be invoked by the magistrate after taking cognizance of the offence on a private complaint. If at all, on receiving a private complaint, the magistrate wants a full-fledged investigation by the police, he can do so under section 175(3) BNSS corresponding to 156(3) CRPC only at the threshold before taking cognizance of the offence. If such an investigation is ordered at the pre-cognizance stage, before taking cognizance, pre-cognizance stage, the police will have to conduct the investigation under chapter 13 of BNSS, that is chapter 12 of CRPC, and it has to culminate in a police report to be filed under section 193(3) of BNSS corresponding to section 173(2) CRPC. If before taking cognizance on a private complaint, then only before taking cognizance, at the pre-cognizance stage only, the magistrate can order an investigation under section 175(3) BNSS corresponding to section 156(3) CRPC. Once that investigation is ordered, the SHO is bound to register an FIR, conduct investigation, and file a charge sheet, a full-fledged investigation under chapter 13 of BNSS and corresponding to chapter 12 of CRPC. And he will have to file a final report under section 193(3) of BNSS, that is 173(2) of CRPC. But once the magistrate has taken cognizance of the offence on a private complaint by deciding to proceed under section 200, that is 223 BNSS, then his only power to order an investigation by the police or anybody else is to be located solely under section 225(1) BNSS corresponding to section 201 CRPC, where such power of investigation by the police is invoked by the magistrate. Such investigation being one only to assist the magistrate to decide whether there is sufficient ground for proceeding. That investigation cannot produce a final report, charge sheet, or police report under section 193(3) CRPC. You may read para 9 of Mona Panwar versus High Court of Judicature, Allahabad, 2011, volume 3, SEC 496. Now, authored by Justice J.M. Panchal. See, private complaint filed, magistrate, instead of going into the private complaint at all, instead of perusing the private complaint at all, forward the private complaint to the magistrate for investigation under 170, under 156(3) CRPC, that is corresponding to 175(3) BNSS. He is not taking cognizance of the offence. He is only forwarding the complaint to the police for investigation. He is not taking cognizance. In that investigation, the police officer is bound to register the FIR, conduct investigation under chapter 13 of BNSS, that is chapter 12 of CRPC, and finally submit a police report, either closure report or a charge sheet, whatever it may be. They have to file. But once the magistrate takes cognizance of the offence on a private complaint by deciding, by applying his mind and deciding to proceed under chapter 16 of BNSS, that is chapter 15 of CRPC, he has already taken cognizance of the offence. Thereafter, the only power of the magistrate to order investigation is under section 202(1) CRPC corresponding to section 225(1) of BNSS. That investigation is not an investigation under chapter 13 of BNSS. That is an investigation by the police or anybody else only to assist the magistrate to decide under section 202 inquiry, that is decide under section 223 inquiry, 225 inquiry, whether there is sufficient ground for proceeding so as to issue process to the accused. That is only purpose of that investigation. It cannot produce a final report, a police report under section 175, police report under section 173 2 CRPC corresponding to 193 3 CRPC. Now, I have given you citation Mona Panwar. Now, this was the position if what the magistrate received was a police report also. The position was the same, whether it was a police report or a private complaint. Before taking cognizance, the magistrate could order further investigation under section 156 3 CRPC corresponding to 175 3 BNSS. But in fact, if you want to know, if you want authorities on that point, the consistent view taken by the Supreme Court was that the magistrate could invoke the power under section 156 3 CRPC, that is 175 3 BNSS, on receiving a police report or a private complaint only before taking cognizance of the offence and not after that. These are the consistent view taken by the Supreme Court. The citations are Devarapalli Lakshmi Narayana Reddy versus Narayana Reddy, AR 1976, Supreme Court 1672, 3 judges. Tularam versus Kishore Singh, AR 1977, Supreme Court 2401. Suresh Chand Jain versus State of Madhya Pradesh, AR 2001, Supreme Court 571. Mohammad Yusuf versus Afak Johan, 2000, AR 2006, Supreme Court 705. Dilawar Singh versus State of Delhi, AR 2007, Supreme Court 2234. Sakiri Vasu versus State of UP 2008, 2 SEC 409. Rasiklal Dalpatram Thakkar versus State of Gujarat 2010, 1 SEC 1. Ramesh Bhai Pandurao Hedan versus State of Gujarat 2010, 4 SEC 185. Srinivas Gundluri versus Sepco Electric Power Construction Corporation 2010, 8 SEC 206. Mona Panwar versus High Court of Judicature Allahabad 2011, 3 SEC 496. Madhav versus State of Maharashtra 2013, 5 SEC 615. 12, number 12. Anju Chowdhury versus State of UP 2013, 6 SEC 384. Then Ramdev Food Products Private Limited versus State of Gujarat 2015, 6 SEC 439, 3 judges. I have given you 13 citations to show that before taking cognizance only, the magistrate had power to forward the complaint for investigation to the police. But in the 3-judge bench decision in Vinubai Haribai Malaviya versus State of Gujarat and others, 2009, AR 2019, Supreme Court 5233, corresponding to 2019, 17 SEC 1, Rohinton F. Nariman, speaking for the bench, 3-judge bench. Other judges were Suryakant and Justice Ramasubramanian. The apex court, in a case instituted on a police report, held that the power under section 156 3 CRPC, that is 175 3 BNSS, can be exercised by the magistrate even after taking cognizance of the offence and until the commencement of trial before the magistrate. But the previous provision regarding private complaint was untouched by Vinubai Haribai Malaviya. And therefore, with regard to private complaint, the position continues to be same that on receiving private complaint, if the magistrate wants a full-fledged investigation by the police, it can exercise the power under 153 CRPC corresponding to 175 3 BNSS before taking cognizance, not after that. In the case of a police report, now after Vinubai Haribai, the magistrate can order investigation by recourse to section 175(3) BNSS even after taking cognizance until the commencement of trial. That is the only change made to this position. Please note that. Am I clear?
Absolutely, sir.
Question number 6.
Question number 6. A magistrate takes cognizance of a cognizable offence on a private complaint. During the inquiry conducted under Section 202 CRPC, that is 225 BNSS, the magistrate directs the SHO of the local police station to conduct an investigation under Section 225(1) BNSS, that is Section 2021 of CRPC. While conducting the investigation, the SHO questions witnesses and takes their signed statements, which are produced by the SHO along with a report before the magistrate. In the course of the subsequent trial of the case, when the Assistant Public Prosecutor, APP for short, with a view to elicit a corroboration, confronts a witness who had given previous statement to the SHO as aforesaid, the defense counsel opposes it by raising two objections. The first objection is that the signed statement was obtained by the SHO in breach of Section 181(1) BNSS, that is Section 162(1) CRPC, and should not be looked into. Another objection raised by the defense counsel is that even if the signed statement could be looked into, it can be used for eliciting a contradiction only as permitted by the proviso to Section 181(1) BNSS, that is Section 162(1) CRPC. Is not the objection raised by the defense counsel sound and valid?
I will explain the question once again. Magistrate receives a private complaint. He takes cognizance of the offence. Therefore, he cannot exercise the power under Section 156(3) CRPC corresponding to 175(3) BNSS. He can only exercise the power under Section 202(1) CRPC. Is it not? 202(1) CRPC corresponding to Section 225(1) BNSS. He has invoked that power and forwarded the complaint he has invoked that power and asked the SHO to conduct an investigation under Section 202(1) CRPC corresponding to Section 225(1) BNSS. The SHO conducts an investigation, questions witnesses, takes their signed statements. SHO takes their signed statements, and after conducting the investigation, he submits a report before the magistrate along with the statements recorded by him from witnesses. Now, during the subsequent trial of the case, when the public prosecutor wanted to prove a corroboration from the statement of one of those persons who were examined by the investigating officer, defense counsel raises an objection. No, I have two objections. One, the police officer has, in violation of Section 162(1) CRPC, that is 181(1) BNSS, obtained signed statements, signature from the witness whom he interrogated. That is forbidden under Section 162(1) CRPC, that is 181(1) BNSS. Number two, even if that objection is overlooked, Section 162(1) proviso, that is Section 181(1) proviso, says that it can be, in the case of a prosecution witness, it can be used only for eliciting a contradiction in the manner provided under Section 145 of the Evidence Act. Now, here what is sought to be proved is not a contradiction, but a corroboration. Corroboration not permitted under Section 162(1) corresponding to Section 181(1) BNSS. These are the objections. Now, is not the defense objection sound and valid is the question. One, taking signature of the statement. Number two, using that statement for the purpose of not proving a contradiction as permitted by section 162(1) CRPC, but for proving a corroboration, which is not permitted by section 162(1) CRPC corresponding to section 181(1) BNSS. This is the objection. Is not the defense objection valid and sound? Now the answer is no. The defense objection is not valid and sound. The bar against taking signature of a person questioned by the police officer is applicable only if the investigation is conducted under chapter 12 CRPC corresponding to chapter 13 BNSS. Now I will read that section. I am reading section 181. Section 181 BNSS corresponding to section 162(1) CRPC. No statement made by any person to a police officer in the course of an investigation under this chapter. Investigation under this chapter. Now, section 225 BNSS corresponding to section 202(1) CRPC is not under chapter 12, not under chapter 13. It is under chapter 16, different chapter. The bar under section 181 applies only to an investigation under chapter 13 of BNSS corresponding to chapter 12 of CRPC. Now, this was not an investigation under chapter 12 CRPC corresponding to chapter 13 BNSS. Therefore, the bar against taking signature and the bar against using it for eliciting only a contradiction, that too if he is a prosecution witness, etc., applies only if it is an investigation conducted under chapter 12 CRPC corresponding to chapter 13 BNSS. I already told you that this investigation under section 202(1) CRPC corresponding to 225(1) BNSS is not an investigation under chapter 12 or chapter 13 BNSS, because it is an investigation for the limited purpose of aiding the magistrate to come to a conclusion whether there is sufficient ground for proceeding. This investigation will not produce a final report. I told you, this investigation will not produce a final report under section 173 to CRPC, that is corresponding to section 193(3) of BNSS. Therefore, this is not an investigation under that chapter. Therefore, the bar against obtaining signature, the bar against using it for any other purpose other than a contradiction, etc., has no application to an investigation under this section, under this chapter. Therefore, the police officer was fully justified in taking the signature of the persons interrogated by him, and the public prosecutor was fully justified in attempting to prove a corroboration of the witness, statement of the witness. This is like this statement of the witness is like any other previous statement which can be used for contradiction as well as corroboration. Unlike a statement given to a police officer under chapter 12 CRPC, chapter 13 BNSS, where the interdict under section 162(1) corresponding to section 181(1) operates. Here there is that interdict, that embargo does not operate. Therefore, the police officer was fully justified in taking signatures, and the prosecutor was fully justified in attempting to prove a corroboration. He can also prove a contradiction of the from this witness with regard to his statement. In fact, according to me, there is a solitary decision rendered by myself from the Kerala High Court, that is Biju Purushothaman versus State of Kerala. Biju Purushothaman versus State of Kerala, 2008 Criminal Law Journal 4488. 2008 Criminal Law Journal 4488. That has explained the distinction between an investigation under Chapter 12 CRPC and an investigation under Section 202 CRPC, which is under Chapter 14. Different, the chapter is different. Therefore, the bar under Section 162 1 CRPC does not operate to an investigation under Section 202 1 CRPC. I suppose it is clear for you. Am I clear?
Yes, sir. Absolutely clear, sir.
Thank you. Question number 7.
I request the audience to also write OK in the chat box if it's clear to them. If they have any doubts, they can put it in the chat box.
Okay.
So question number 7. Under which provision can a complaint be dismissed?
Dismissal of a complaint can be done under Section 226 BNSS, corresponding to Section 203 CRPC. Only at the post-cognizance stage. We have seen the sufficient ground for proceeding is one of the components, one of the yardstick to be applied under Section 203 CRPC, 226 BNSS. Therefore, the dismissal of a complaint can be made under Section 226 BNSS only at the post-cognizance stage. Then, yet another provision enabling dismissal of a complaint is under Section 227 4 BNSS, corresponding to Section 204 4 CRPC, if the process fee ordered by the magistrate for summons or warrant has not been paid, in spite of order, it has not been paid, then also the complaint can be dismissed. These are the two provisions. Both dismissals are under at the post-cognizance stage. Both dismissals are at the post-cognizance stage. That is, after the sworn statement has been recorded, after inquiry, if any, under Section 202 corresponding to Section 225 BNSS has been conducted. Not at the very stage of filing the complaint. At the very stage of filing the complaint, the complaint cannot be dismissed under Section 203 CRPC corresponding to Section 226 BNSS. It can be dismissed only at the post-cognizance stage. Yes. Question number 8.
So question number 8. If the complaint on the face of it does not make out any offence, is it not permissible for the magistrate to dismiss the complaint at the threshold under Section 226 BNSS, that is Section 203 CRPC?
So I already told you that the dismissal of the complaint under Section 203 or 226 BNSS is impermissible at the threshold, at the very filing of the complaint. But take a case where a private complaint does not make out any offence. It does not make out any of the ingredients of an offence. Why should the precious time of the magistrate be wasted? Magistrate has got so many work. Why should the precious time of a magistrate be wasted on such a complaint which does not make out any of the ingredients of the offence? Should not the magistrate be clothed, be armed with a power to prematurely terminate the proceedings? Should he not be permitted? For that, we have only a judge-made law. There also, I think I have, there's a decision rendered by myself from the Kerala High Court. That is Biju Purushothaman versus State of Kerala. Same citation. 2008 Criminal Law Journal 4488. Where it was held that, I'm sorry, Biju Purushothaman was for the earlier case. Dr. K.V. Bhavadas versus State of Kerala, 2008, 3 KLT 56, rendered by myself. Dr. K.V. Bhavadas versus State of Kerala, 2008, 3 KLT 56. Then Biju Purushothaman also. Biju Purushothaman versus State of Kerala, 2008 Criminal Law Journal, I have already given you the citation. 2008 Criminal Law Journal 4488. Then yet another decision by myself, 2000, that is Ragesh, R-A-G-E-S-H, Ragesh P.K. versus State of Kerala, 2010, Volume 2, KLT 557. Fortunately for me, there is a subsequent decision rendered by the Supreme Court taking the same view. What I said was, dismissal cannot be done. What I held in those decisions is that you can dismiss the complaint by resort to section 203 CRPC, that is 226 BNSS. But the complaint can be rejected. Don't use the expression dismissed. Dismissal under section 203 CRPC is impermissible at the pre-cognizance stage, when the complaint has been filed. The moment the complaint has been filed and it does not make out any offence, you cannot dismiss the complaint under section 203 CRPC corresponding to section 226 BNSS. But you can reject the complaint. Otherwise, the precious time of the court will be wasted over a complaint which does not even make out an offence. That is why this view was taken. Fortunately for me, the Supreme Court also subsequently affirmed that view. Of course, not without referring to my decision. Mahmood ul Rahman versus Kazir Mohammad Tunda. Mahmood ul Rahman versus Kazir Mohammad Tunda. AR 2015 Supreme Court 2195. AR 2015 Supreme Court 2195. In yet another case, I had a situation where it was a rejection at the threshold because their complaint did not make out any offence at all. But the magistrate used the expression dismissed, and he dismissed the complaint under 203 CRPC. I said that merely because a wrong expression has been used by the magistrate, you can't treat the rejection as dismissal under section 203 CRPC. It can be treated, that dismissal can be treated as a rejection of the complaint at the threshold. That is Raju Pulangara versus State of Kerala. 2008, Volume 2, KLT 467. 2008, Volume 2, KLT 467. Am I clear?
Yes, sir. Absolutely.
If a private complaint on the face of it, ex facie, does not make the ingredients of the offence, there is no point in proceeding with the complaint. The magistrate should have the power to prematurely terminate that complaint. Therefore, courts have devised a power to reject the complaint, though not dismiss. So, rejection can be, the power of rejection can be exercised by the magistrate to terminate the proceedings prematurely. But if you want to dismiss the complaint, you can do it only after cognizance. This rejection is at the pre-cognizance stage. Yes. Question number 9.
Question number 9, sir. If the inquiry under section 225 of BNSS, that is section 202 CRPC, conducted in the absence of accused, reveals any of the exceptions to the penal offence alleged, thereby tending to exculpate the accused, whether the magistrate will be justified in dismissing the complaint under section 203 CRPC.
See, from the averments in the complaint and the statement of the sworn statement of the complainant and the witnesses, it is clear that one of the exception to the penal offence is also made out. Now, all of you know that the under section 6 of the Indian Penal Code, corresponding to section 3 of the Bharatiya Nyaya Sanhita 2023, that section 6 of Indian Penal Code and section 3 of PNS declares that every penal provision, whether under the IPC or BNS or otherwise, is to be understood subject to the general exceptions in chapter 4 of IPC, that is chapter 3 of BNS. Every offence should be understood subject to the general exceptions. Take a case where an insane person commits an offense. An insane, the complaint alleges that the offender is an insane person. But at the same time, the complaint also alleges that he has been visiting regularly a psychiatrist for treatment, and he was paranoid. He was having paranoid tendencies. That is also there in the evidence. This means um, a person who is non-composed mentis, who does not have the mental capacity to reason out whether it is an offense or not. He is non-composed mentis. It's a clear case where Section 84 of the Indian Penal Code will clearly apply. In such a case, when the statements of the complainant itself, statements themselves show that the exception under Section 84 is applicable to the offender who is alleged to have beaten the complainant, then should the magistrate close his eyes to that? Magistrate need not close his eyes, because every offence should be understood subject to the general exceptions. Section 84 of Indian Penal Code is one of the general exceptions in Chapter 4 of the Indian Penal Code. Therefore, corresponding to Chapter 3 of BNS. Therefore, when the statement of the witnesses itself, it is clear that the exception to Section 80, to the offence, namely under Section 84, clearly applies to the case. Then the magistrate need not proceed further and issue summons to the accused. He can terminate the proceedings by dismissing the complaint. This is a very important decision, and I will read one observation from paragraph 10 of Vadilal Panchal versus Dattatreya Dulaji Gadigokar, AR 1960 Supreme Court 1113, AR 1960 Supreme Court 1113, 3 judges, judgment by Justice S.K. Das. Paragraph 10, I am reading from paragraph 10. In arriving at his judgment, he, that is the magistrate, is not fettered in any way except by judicial consideration. He is not bound to accept what the inquiring officer says, nor is he precluded from accepting a plea based on an exception, provided always there are satisfactory and reliable materials on which he can base his judgment as to whether there is sufficient ground for proceeding on the complaint or not. If the magistrate has not misdirected himself as to the scope of an inquiry under Section 202 CRPC and has applied his mind judicially to the materials before him, we think that it would be erroneous in law to hold that a plea based on an exception can never be accepted by him in arriving at his judgment. So saying, the Supreme Court accepted the dismissal of the complaint by the magistrate. So this is an important principle of law, that where in fact, we very often come across cases where police unnecessarily charge people for grave offences, where the evidence collected by during investigation itself shows that a very valid defense is available to the accused. The valid defense available to the accused by way of an exception is also made out in the materials collected by the police. Still they charge the accused. Exercise of right of private defense. There are situations where a lady who is attempted to be molested, in an attempt to exculpate her or explicate her from the clutches of that randy objector, she commits an offense. It is not what Section 96 of the Indian Penal Code says is nothing is an offense. Nothing is an offense if done in exercise of the right of private defense. So it is no offense at all if done in the exercise of the right of private defense to body or property. Therefore, if the exercise of the right of private defense is justified in a given situation, law says it is no offense at all. Whatever the person did, the victim did, is no offense at all. Therefore, why deny the accused that the benefit of that exception, and instead of drag him to the court and to the ordeal of a trial? These are all matters which you should think over. There is one more decision relying on 60 Supreme Court, that is Pramada Nath Talukdar versus Saroj Ranjan Sarkar, AR 1962 Supreme Court, 876, 3 judges bench. The judgment is by Justice J.L. Kapoor. Now we come to the last question of today's session. Question number 10.
So question number 10. Is it not the accused entitled to participate in the inquiry under section 223 and 225 BNSS, that is section 200 and section 202 CRPC?
The consistent view taken by the Supreme Court is that during the inquiry under section 200 and 202 CRPC, corresponding to sections 223 and 225 BNSS, the accused has no right to participate. Why? Because process is yet to be issued to the accused. Accused is yet to be invited to the court to participate for the trial. Before inviting him to the court to participate in the trial, how can he participate in the trial? He has no locus standi. To address the court. He can address the court only when he is served with summons, served with process, and asked to appear before court to answer a charge. That's the 202 and 200 and 202 CRPC inquiry, that is inquiry under sections 223 and 225 of BNSS, are conducted before the appearance of the accused, behind the back of the accused. He is not expected to be present before the court. In fact, the Supreme Court has taken the view that even if he accidentally happens to appear before court, he can only watch the proceedings. No, supposing the accused, he had come to court for some other case, then he finds that there is a case in which he is an accused. A private complaint inquiry is being conducted. He can only watch the proceedings because summons has not been issued, process has not been issued to him. It is only when process is issued to him, inviting him to appear and contest the case, he gets the jurisdiction, locus standi, to appear before court and participate in the proceedings. So this is at the pre-process stage. Where the Supreme Court has been very consistent in holding that he has no right to participate. Even if he is present, he can only watch the proceedings. That's all. I give you the citations. Vadilal Panchal versus Dattatreya Dulaji Gadigonkar, AR 1960 Supreme Court, 1113, 3 judges. Then Chandra Deo Singh versus Prakash Chandra Bose, 1964, 1 SCR 639, again 3 judges. Then Nagavva versus Veeranna Shivalingappa Kanjalji, AR 1976 Supreme Court, 1947. Justice Murtaza Fazlali. Then Shashi Jaina versus Kadal Swain, 2000, AR 2004 Supreme Court, 1492. Justice B.N. Agrawal. Then lastly, para 53 of Manhari Bai, Mulji Bai Kakadia versus Shailendra Bai Mohan Bai Patel, 2012, volume 10 SEC 517, 3 judges. Justice R.M. Lodha is the author of the judgment. Now, in all these cases, it has been very categorically held that the accused does not have any right to participate in the proceedings before the magistrate during the inquiry under section 223 and 225 rather 200 and 202 CRPC. Now, before parting with this case, I will make one submission. If the accused has no right at all to participate in the inquiry under sections 223 and 225 BNS, it is not known as to how and on what principle the framers of BNSS have allowed a right of hearing to the accused under the first proviso to section 223(1) BNSS, but at the same time maintaining the stage under section 227 BNSS to issue process to the accused on being satisfied that there is sufficient ground for proceeding. So, therefore, the scheme under the CRPC has been maintained by BNSS also by stating that it is only if the magistrate is satisfied that there is sufficient ground for proceeding can he issue process to the accused. Then why invite the accused at a stage before process to answer the to address the court regarding the cognizance of the taking cognizance of the offence. Taking cognizance of the offence has always been understood to be at the pre-process stage behind the back of the accused. It is at the pre-cognizance stage, taking cognizance. And accused can, after taking cognizance, he cannot even, as I told you, the criminal court has no inherent power. So it cannot retrace its step backwards from the post-cognizance stage to the pre-cognizance stage. There are ever so many rulings on that point. In fact, after overruling KM Matthew versus State of Kerala, it was held that magistrate does not have the inherent power of review. Therefore, he cannot, after crossing a particular stage, go back to that stage. Therefore, I am at a loss to understand as to on what basis is a right of hearing is given to the accused even before the cognizance is taken. Now, the unfortunate position is we had a situation where at the stage of framing charge, the accused is given a right of hearing, like the prosecutor also. That right of hearing was once interpreted by the Supreme Court to hold that exercising the right of hearing, he can even produce documents in support of his defense. That decision was overruled by a 3-judge bench of the Supreme Court in State of Orissa versus Devendranath Pati, 2005 Supreme Court. There, the Supreme Court said the court is entitled to examine only the documents produced by the prosecution along with the police report. Only those documents, no other. Even the right of hearing given to the accused is only with regard to those documents. He can say that those documents are self-destructive. He can argue, but he cannot adduce evidence to rebut or controvert the documents produced by the police. That right the accused gets only when he is called upon to enter on his defense at the appropriate stage. This is what the full bench, 3-judge bench held. Thereafter, the Supreme Court has affirmed that view also. There is a decision by Justice K.M. Joseph also on that point. Now, if a right of hearing is given even before taking cognizance of the offence, he may ask for evidence. He may ask for document to be produced to show that the statement of the statement of the complainant is false. I can adduce the evidence. If that is permitted, the prosecution will never end, and he will get one more chance when he is called upon to adduce evidence. It is going to be confusion confounded. I don't know what the Supreme Court will ultimately say. With that, we conclude today's session. Hopefully, we can continue at 11 a.m. tomorrow, provided my sound is okay. Thank you.
Absolutely, sir. Thank you so much for such an enlightening session, sir.
Thank you.
I would just like to quickly make 2 announcements very quickly with your permission, sir.
Sure.
So LiveLaw Academy has launched a scholarship test for its Judicial Services Examination Preparation course, which is to happen on this Sunday, that is on 20th of April. I request all of you all to register for the scholarship test and a 7-day boot camp which follows it. I would also like to bring to your attention that if Justice Ramkumar sir's health permits, we will be continuing with this session tomorrow at 11 a.m. I hope to see you all there, and we will take up the doubts which everyone has in the following session itself.
Yes.
If you have any doubts, you can write us, you can mail it to us, you can WhatsApp us. We will surely take all doubts in the following session of part 2.
Yes.
Thank you so much, sir, for this enlightening session. It has cleared whys and whats of this complex subject. We are deeply indebted to you. Thank you so much, sir.
Thank you.
Have a great evening, sir. Good night.
Good night.